Viewers, Namaskar. We come to you with judgments for the second half of February 2026. There has been a flurry of judgments. I think 4 or 5 Supreme Court judgments and a whole lot of NCLAT judgments. And if I really wanted to do a video with all the judgments, important judgments even, the video would last for about 3 hours. And I reckon a video, this old man speaking for 3 hours, will be less enjoyable than watching a video on YouTube on a film. So we have curtailed the videos, we have curtailed the number of judgments to and brought it down to 12. This will marginally increase the length of the video, but still then you will find it interesting. In case during March we get some space, then we'll try to include some of the judgments that I have missed, I could not include, in the March video. With this, I take you over to the presentation.
Viewers, we are coming to section 5.6, which deals, section 5, subsection 6, which deals with the topic of dispute. You will have a question as to why I am putting this as a dispute. This should go into financial, because this case is regarding homeowners. And this should go to 5.8, but no. Often a question comes, who is responsible for not delivering the project? Is it the developer or the landowner? So this case essentially deals with the dispute pertaining to who is going to be the responsible person. The topic says the issue regarding joint and several liability of the landowner and the developer has to be decided in the facts of each case. This is the case of Honorable Supreme Court dated 20th of February. The cases of Sri Ganesh Chandrasekharan and others versus Messrs. Unishar Homes LLP and others. I have just picked up the verdict of the Supreme Court. I haven't gone into the background of the case because that won't really make much, because this is an NCRTC case. But this doesn't deal with with Insolvency Bankruptcy Code. So excerpts of the judgments of Supreme Court, just the judgment part, will be relevant. So I would request you to go through this. Let me take you over to the slide. Now, as I said, the topic is the issue regarding joint and several liability or responsibility of the landowners and the developer has to be decided on the facts of his case. What happens now? There is a landowner and a developer. They enter into a joint development agreement. And then a GPA, purchase agreement, or how the project is going to be executed. So in this case, the court observed that the JDA executed between landowner and the developer provides for mutual indemnities between the parties. The landowner would automatically try to indemnify himself and say that he is not responsible for delaying the project. The construction is solely dependent on the developer. The GPA executed by the landowners in favor of the developer authorized the developer to enter into sale agreements, execute conveyances, receive consideration, and complete registration formalities in respect of developer's share. So that means developer is the one who is going to develop the project, do the sale, collect the money, and execute the conveyance. So the construction must be carried out by the developer. Delay in delivery of the possession is in respect of flats falling to the share of the developer. So if there is a delay, who's responsible? It is the developer who is responsible. Because the construction must be carried out by the developer. The delay in delivery of possession in respect of flats falling to the share of the developer. The lapse on the part of the developer, the landowners. The lapse on the part of the developer, the landowners who are in no way concerned with the construction are not liable for deficiency in service, since the developer has indemnified them against acts of commission, omission, and in construction. So normally what happens when there is an agreement, JDA, the developer indemnifies the landowner for acts of commission, omission in construction. So they are not responsible. The appellant, as far as if the appellants go to RERA or they go to NCRDC or to IBC, go to IBC forum, the appellant's interest will be fully protected as landowners as well as developer will be directed to transfer the title. But when they go to court, the court will direct both landowner and the developer to complete the construction and deliver the title. The issue regarding joint and several responsibility or several liability of the landowners and developer has to be decided in the facts of each case. So you cannot always hold landowner liable. It is usually the developer who is liable for lapse in the construction, for lapse in delivering of the project. But this is a very important case because often we see that both landowner and developer are being dragged into an insolvency process. But then the merits of each case have to be looked into. And this is what makes this case exceptional. And I thought of sharing this with you. So with this, we move on to the next topic. We are on the screen of section 5, subsection 8, which deals with financial debt. We are coming to topic 76. Financial debt is important, very, very important. IBC rests on it. So it's but natural that we will have so many topics. Now, 76 says that where a mortgage it contains a covenant to pay, it constitutes an English mortgage, creating a direct financial liability on the mortgagor and qualify the creditor as a financial creditor under section 5(8) of the code. Let me read it out once more. Where a mortgage deed contains a covenant to pay, it constitutes an English mortgage, creating a direct financial liability on the mortgagor and qualify the creditor as a financial creditor under section 5(8) of the code. We have two cases in this thing. This week itself, JC Flowers Asset and Reconstruction Private Limited versus Vithalem Dahake, company appeal so and so, and Vistra ITCL, Vital Madhukar Dahake, same, company appeal so and so. The second one is 76 page. The first one is about 44 or 44 pages. I would rather select JC Flower because this case is more condensed, So you will find it more, both are very interesting. Both dwell on various topics. Now, before going into it, we need to understand what is an English mortgage. English mortgage is a type of mortgage where a mortgager, in the form of security, gives the asset to the mortgagee. And once the repayment is done, another deed is created and the asset is returned. So here actually the ownership transfers. And that is why the covenant of pay has become so important. Now in this particular case, the mortgage was created by the CD for a group company. And that makes this more interesting because the question is, Section 5(8), we are talking of financial debt. The mortgage is created for another company in the group. So how does it constitute a financial debt? This is a very, very interesting read. Both the cases, JC Flower and the other, both are very interesting. I would strongly recommend because this is an excellent judgment. And I would strongly recommend my viewers to go through this. But for the sake of convenience, I take you over to the slide which I prepared for you. Now, originally, this loan was sanctioned by Yes Bank Limited. Subsequently, Yes Bank had assigned this loan to a asset reconstruction company. Now, the claim of the appellant for the sum of 62 crores pertain to corporate guarantee provided by the corporate debtor against a loan granted by Yes Bank to Radius Estate Developers Limited. The same claim had been put under verification by appellant and was considered to be other secured creditors because it was not given to the company. In terms of the mortgagor, the company had the covenant to pay for the financial debt. And Supreme Court held that it is a very clear appellant as a mortgagee is entitled to recover any deficiency in any form from the mortgagor. The security trustee was acting on behalf and for the benefit of the secured lenders and consequently the corporate debtor. When secured lenders and secured trustee are parties to a composite agreement, such undertaking and guarantee under Section 126 of Indian Contract Act 72 and therefore constitute a financial debt under Section 58 of Contract Act, 58 of Insolvency Bankruptcy Code. Where mortgage deed contains a covenant to pay, it constitutes an English mortgage, creating a direct financial liability on the mortgagor and qualify the creditor as a financial creditor under Section 58 of the Code. Direct disbursement to the corporate debtor is not sine qua non. Nowhere in Section 58 it has been stated that the money has to go to the corporate debtor. Money has to be disbursed and there should be commercial effect of borrowing. But where is it said that it has to directly go to the corporate debtor? Nowhere in the section it is mentioned. A covenant to pay is a legal binding promise in a contract where one party commits to pay a specified sum to another, often on demand or a fixed date. Commonly seen in loan agreements, security documents, promissory note and deeds, especially in English mortgages. Explicit covenant to pay clauses in mortgage deed elevate the liability to financial debt, distinguish it from pure security. So this is a financial debt, and this is very, very important. So with this, we move on to the next topic, but this, mind you, this is very important, and you should go to the other judgment also. Viewers, you can see on your screen the dashboard of Section 7. We are coming to topic 109, which is very much known to you. We have handled this particular topic. We have dealt with this particular topic a number of times. It says that under Section 128 of Indian Contract Act 1872, the liability of the guarantor is coextensive with that of the principal debtor, but the coextensive nature does not imply automatic release of one for the settlement with the other. So, settlement with one doesn't mean the settlement with the other. We have had multiple cases on this. You can proceed simultaneously against the principal borrower and the guarantor, be it a corporate guarantor or personal guarantor. This is known to us. Now, we have a case of ICICI Bank Limited versus Era Infrastructure India Limited of Supreme Court. And which is a very recent judgment. Just don't go by the 2019. This is a case, this judgment came out possibly a day or two earlier. Now, this is a very interesting lead. The Honorable Court, Supreme Court has considered the same thing elucidated. This is more of an opinion kind of a judgment, in which Supreme Court has dealt with the subject of simultaneous proceedings, has dealt upon IBC as a recovery proceeding, election of claims, double enrichment, the need for reform, etc. So this makes it a very interesting lead, and I would strongly, this is needless to say, this is a must-read judgment. But however, let me stop the screen share here and take you to the slide which I prepared for you. Now, the court held that it has consistently been found that recovery is not the objective of proceedings under IBC. The fact that recovery is central to the process of insolvency resolution, as resolution itself would be evident from the fact that decision taken by creditors would be in their interest, that is to bolster recovery. So how sweetly Supreme Court has said that though we say that it is not for the purpose of recovery, but it is actually for the purpose of recovery. Because in a resolution plan, when passing the resolution plan, what will be the interest of the creditor? To maximize their recovery, to bolster recovery. In fact, it cannot be denied that maximization of the value of corporate debtors' assets is also to ensure the benefit of creditors. The question whether simultaneous proceeding against corporate debtor and or guarantors can be maintained or not is no longer res integra. It is known that it can be. In view of the preamble of the code, which envisions maximization of the value of asset, principles of contract act cannot be made applicable to IBC in strict sense of the term. Now, since liability is coextensive, forcing the creditor to elect would essentially make it sacrifice a part of its claim. This is not how guarantee works, particularly when court does not provide for such an action. So you cannot say that once a resolution takes place, that he doesn't have the right. Regulation 12A of 2016 regulation set up an obligation upon the creditor to update its claim when it is satisfied, either to partly or fully, to inform about the same while filing the claim. In addition to Regulation 12A, under Regulation 14, it is the responsibility of the resolution professional to independently assess the claim and post the correct claim. So it is known that there will not be code. There is enough safeguards within the code so that the claim doesn't get. We don't create a bubble of claim. It doesn't get magnified. Considerable jurisprudence of IBC, including concepts such as simultaneous proceedings, group insolvency, has flowed from judgments of this court as well as NCLAT and NCLAT. The legislature as well as IBBI has been receptive to judicial nudges and has brought out necessary policy changes from time to time. So this is how the IBC has flourished. And this is how IBC will flourish also. Well, of course, there are still many shortcomings, many drawbacks are there, but we are progressing on the same. So we have to look at IBC as a very positive mechanism. And that is the motto. And that is the motto of Guide to IBC, come to think of it. Because this is beneficial for the economy. This is beneficial for the industrial growth of the nation. And that is the whole purpose of doing this website, for doing this podcast, so that people get to know about it, not just the insolvency professionals, everybody should know about it. So with this, we move on to the next slide. Here you can see on your screen the dashboard of Section 7. We are concerned with topic 92, which says that Honorable Supreme Court in M. Suresh Kumar Reddy versus Canara Bank and others in civil appeal number so-and-so held that the Vidarbha judgment was passed in the context of certain set of facts and cannot be said to apply ipso facto as a general practice. The case particular which we are going to take up deals with Section 7 as well as Section 10A. So let me show you the topic of Section 10A as well. It is topic number 8, where it says that where a default has been committed by corporate debtor prior to commencement of Section 10A period, the application under 7 and 9 cannot be held to be improper. So let us look at the case from in Section 7, because 10A part is a little smaller. We can cover that in the slideshow. This case is of 18th of February 2000, 26. The case is Power Trust, promoter of Hiranmai Energy Limited versus Bhuvan Madan, civil appeal number so-and-so, Supreme Court. The case excerpts is here. Though the headlines will give you a very good idea about what the case pertains to, I would strongly recommend that you go through the case. Because there are there are touch lines. The court has rated in judgments of various other of Supreme Court, and which would make much more logical for you to study and obtain in-depth knowledge. But in order to make things brief and precise, I take you over to the slide which I prepared for you. Here you can see the slide on your screen. Now this is a power project which was being set up in Haldia in West Bengal. The company took availed loan from financial institutions and banks, which was insufficient. The project cost had an overrun. They took another sum of money from banks in 2015. In 2018, the company was declared to be NPA. Despite company making various restructuring proposals, things didn't work out. The company went to High Court also. Calcutta High Court had said specifically that the Section 7 petition moved by the court by the financial creditors at NCLT was absolutely proper, should not be interfered with. However, division bench suggested to the lenders that they could look into the prayers made by the corporate debtor, and make a decision thereof. But they were of the opinion that this was not possible. The lenders had suggested that the company should maintain proper DSRA. The company should obtain a better EPA with West Bengal Power Distribution Authorities. The company should maintain a balance of 83 crores, which they could give for project-related urgent payments, and 125 crore working capital. And the company should run at least for 72 hours with full capacity, which was never possible. The matter went to NCLT and admitted the company to Section 7 and commenced the CIRP. The company ran to NCLT. NCLT upheld the judgment of NCLT Kolkata. Then the company went to Supreme Court. The first question was, the first objection was that the default falls in 10-day period. The Supreme Court held that even if the second proposal, restructuring proposal, is considered, second restructuring proposal subsumes the first restructuring proposal dated 29/9/2020, whereby the first installment fell due on 31/3/21, which was beyond the Section 10A period, initial period of 25/3/20 to 24/3/21. Beyond that, the court completely agreed with NCLAT that the preconditions which were mentioned by the lenders were not adhered to, and thus the default continued. Default is not only in terms of money, default is in terms of the company, whether the company is viable, company is running on it. And so many things were told which they had not been able to form. So the date of default would relate to 31/3/2018. When the petition was submitted in 2021, which was within the limitation period, and court held that there is no question of 10A applying to this. Now, with regard to validity of CIRP, as I had mentioned to you, the banks maintained that the restructuring proposals were underpinned on pre-implementation conditions, which the corporate debtor failed to fulfill. And the company said that they had made in between some payments, which should be considered to be pertaining acceptance of restructuring proposals. The court held that this cannot be held to be novating the earlier loan agreements. And the default continues. And even if you look at from the point of view of Section 19 of Limitation Act, small payments would exceed the extend the date of extend the date of limitation. So this would in any case not help the company. And look at this. What does Section 7 say? The court, Section 7, it has been held that it is with regard to Section 7, it is the default which is of the main concern. So court is not to look into anything beyond that, and which was established. And as I had mentioned, that the decision in Vidarbha Industries cannot be read and understood as taking a view which is contrary to the view taken in Innovative Industries and E.S. Krishnamurthy. The view taken in Innovative Industries still holds good. It was held in M. Suresh Kumar Reddy versus Canara Bank, the Honorable Supreme Court, very recently. I think I have covered that in one of my podcasts. The company lastly came with the idea that DVC had submitted a resolution plan, which was accepted by COC. And company said that they had submitted a repayment plan, a restructuring plan, which was better than COC. The plan submitted, the resolution plan submitted by DVC. The court, in a simple one-liner, said that it is strike law that commercial wisdom of COC to accept resolution plan over another cannot be a second guess by the court. So DVC had, so this was not acceptable. DVC applied to Supreme Court that because the court had granted a stay order, they applied to the court that the stay order is delaying of the CIRP process is having tremendous financial implications. So the stay order was lifted and the CIRP was continued. So this is a nice judgment, a very interesting read, gives a fresh idea about Section 7, revises the thing. So I would recommend the viewers to go through this. So with this, we move on to the next topic. Viewers, you are on the screen of Section 33, which is the initiation of liquidation. We are coming to the topic number 43, which says that after concluding that resolution plan is in violation of statutory provisions, the adjudicating authority can direct for liquidation under Section 33, subsection 1, subsection B. This is the case of Sumit Mehta versus Vinod Tarachand Agarwal RP. Civil application number 2. And so I've already read out the basic highlights. So highlight of the case. Let me go to the case. Now this is a excellent judgment, I would say. And going through the judgment, it's a very interesting read. Going through the judgment will give you a lot of insights. Excerpts of the judgment featuring on the website will give you a lot of knowledge and it'll be entertaining also, I must say. This is rather different. So it's better in order to make things precise and more understandable in this presentation. Let me stop the screen share here and take you to the slide. You can see the slide on your screen. Now, this is a peculiar case. In this, the company sold all its assets, and they had only a computer system left. There was a resolution plan submitted by Sumit Mehta, and there was only one member in the committee of creditors who approved the resolution plan. But the resolution plan, which was when it was filed by the RP, was rejected by Chandigarh NCLAT. Now, the highlights of the case is very important. So let me give you a glance of the highlights. The adjudicating authority in the impugned order has clearly noticed the parameters of limited scope of interference by adjudicating authority. We know that commercial wisdom of COC is not justiciable. So here the adjudicating authority had gone into depth of the resolution plan and clearly noted the limited scope of interference of the adjudicating authority. and opined the tribunal cannot remain a mute spectator where very anchor of the insolvency resolution process, the bona fide and the commercial judgment of the COC is corroded by patent arbitrariness and opacity. By selling assets of the company, the company did not have machines and plant or building can be used later on to carry on business. The RP's information memorandum noted that the company is not a going concern. Total liquid assets as on 6/12/2024 were cash 14,509. HDFC Bank balance was 34,25,228. Bank FD in Cosmos Bank was 9 lakhs. Total liquid assets came to 43,39,000. The assets ultimately will be owned by the RA if the plan is approved against the plan value of 53 lakhs. Look, 43 lakhs is the net value, liquid asset, and the plan is of 53 lakhs. There are many additional current assets, including potential tax asset in the form of business loss of more than 20 crores. Now, what does 20 crore loss mean? That will be carried forward, and that will be offset against the profits of the company, the RA who takes over, and the value of which will be at least take it at 30%. That will be 6 crores. The liquidation value is 47 lakhs 43,000, which mostly comprises of cash on hand, bank balance, fixed deposit in bank, against which the resolution plan value is 53 lakhs. When the corporate debtor had liquid asset of more than 43 lakhs, no reason forthwith coming as to why a loan of 8 lakhs was obtained on 17/1/2024, and immediately thereafter, on 4/3/24, a Section 9 application was moved. A loan of 8 lakhs from Mahadev Construction, who happens to be the Committee of Creditors, sole member of the Committee of Creditors, on 7/1/2024, which is a minuscule of the amount in comparison to cash deposit of 24 lakhs 27,000 due to sale of asset. The adjudicating authority noticed Regulation 38(3) of CI regulations and has concluded that the resolution plan failed to specify the criteria laid down in the above regulation. The RA has no plans to provide resolution to the corporate insolvency. The adjudicating authority on valid reasons have observed the resolution plan is not commercially feasible and viable, which is the primary condition for approval of a resolution plan. Adjudicating authority, after coming to the conclusion that the resolution plan is in violation of statutory provisions, have directed for liquidation under 33(1)(d). The order of adjudicating authority thus cannot be said to be beyond jurisdiction of adjudicating authority. So we have in the last presentation also, when last broadcast also, had come up with a case in which the commercial wisdom of the COC was challenged and was not approved by the adjudicating authority. And this is also an exceptional case. And that is why this is an interesting read. And I would urge my viewers to go through the judgment. So with this, we move on to the next slide. Viewers, we are on the screen of regulations pertaining to liquidation, especially initiation of liquidation. We are coming to Regulation 2B, which deals with compromise and arrangement. This particular case, this is topic 21, which says that a compromise or arrangement can also be entered into IBC proceeding if liquidation is ordered. Now, I have put this in section 255 also, because section 255 deals with Amendment of Companies Act 2023 pertaining to Insolvency Bankruptcy Code being introduced. But you will get the case both in 255 and Regulation 2B also. This is the case of Omkara Asset Reconstruction Private Limited versus Amit Chaturvedi and others. This is a Supreme Court judgment, very recent judgment. You can see 2025, this came out in the later part of February. Let us go to the case. This is a very, very interesting read because this deals with the transition, of a winding up proceeding coming to insolvency bankruptcy court and how this has evolved and what is the benefit of it coming to insolvency bankruptcy court. Honorable Supreme Court has gone in depth with various judgments, Section 230, and various decisions of appellate tribunal. So this is a very, very interesting read. And to go through the details of the case will give you a very good idea about the case. Now let me take you to the slide which I prepared for you. Now earlier, in Section 391 of Companies Act, they used to deal with compromise and arrangement between company and its creditor and required a 3/4 value of the debt to agree on a compromise and arrangement with voting. In this particular case also this happened. The order was supposed to be filed with the register within 14 days from the such order under Rule 81, which was not done. It remained pending. It continued the inaction of Annexure 1.3. I mean, this is the filing of the order for almost a year. And so the scheme of arrangement was withdrawn. The creditors went to SARFAESI Act and approached DRT for a recovery certificate in the original application. The debt, which was 62 crore, had grown to 150 crore. There is no plausible explanation offered by the company for the delay of almost 10 years in moving to the court for sanction of the scheme, in terms of which it would have definitely become redundant by mere passage of time. Because there is a limitation. You cannot keep things in abeyance like this. A scheme of arrangement, terms of which were as on the year 2008, would have thus become redundant and inoperative as of now, or even in 2023, when filing was done before the Register of Companies, which make its way, for all practical purposes, defunct. There would be no reason to stall IBC proceeding on the ground of judicial discipline based on the pending proceedings before High Court. So, a petition under Section 7 or 9 is an independent proceeding, which is unaffected by winding up proceeding and which may be filed qua some by the company, the same company. The winding up proceeding, whosoever has filed, can file the same petition under Section 7 or Section 9. A compromise or an arrangement can also be entered in section under IBC proceeding. If liquidation is ordered, we have a regulation 2B for that. What is important is that under Companies Act, it is only winding up that can be ordered. But whereas in IBC, the primary emphasis on the revival of the corporator through infusion of new management. So you look at the purpose of winding up and IBC are entirely different. There you are looking at only winding up, whereas here there is a possibility of a revival by induction of a new management, by induction of new capital, by bringing in new technology. So this is an altogether different platform and can be used for a very productive purpose. There is no reason to sustain the order of appellate tribunal, and we set it aside. And the same, restoring the order of company law tribunal, the adjudicating authority under IBC. The IRB hence would be entitled to proceed, and our interim direction to keep the management in the loop for the day-to-day affairs stands vacated. So Supreme Court ordered that the CIRP will continue. Forget about the winding up. Let the IBC continue. This is a beautiful judgment of Supreme Court, wherein they have brought in the difference of winding up petition, IBC, recovery through IBC, and how the mechanism should operate. And I would strongly recommend my viewers to go through this. I would have definitely taken up more videos in this particular presentation, but let's see if we can.
Viewers, I suppose you have enjoyed the part of the judgments that we have come up with. They're really interesting and more are going to follow. Please subscribe to our channel. Please like the videos, put in your comments and note and share the video with everyone, all your friends and colleagues.
Viewers, you can see the screen of section 36, which deals with liquidation estates. We are coming straight to topic 18, which says that in terms of section 36(3)(a) and G of the code, any asset over which corporate debtor has ownership right becomes the part of the liquidation estate of the corporate debtor. The case we are going to deal with deals with both section 36 as well as section 67. So let us go to section 67. In section 67, we are coming to topic number 15. That is, fraud and justice cannot dwell together. If fraud is proved, even finality of litigation cannot be pressed into service to absurd limits when fraud is unraveled. In this particular case, both sections are attracted. This is the case of 20th of February 2026. Let me show you the case. It is the case of Messrs. SSMP Agro Export Private Limited and others versus Mr. Yogesh Sethi, liquidator, company appeal, so and so. This is a 41 or 43 page judgment. As usual, if you go through the highlights, you will understand the case. But going through the case will be excerpts of the case as featuring on the website will give you a deep insight. And it will be a very interesting read because then you can understand the full story behind it. So with this, I stop the screen share here and take you to the slide. Now, in this particular case, what happened was this was a family concern. The mother was Braj Kishori Devi. She had a son, Manoj Kanwar, wife, and two sons. Now, SSMP Industries Limited, the shares, 99.97% shares were held by Manoj Kanwar, his wife, and his mother, Mrs. Braj Kishori Devi. His two sons owned another company, which was, that is Sagar Kanwar and Shrey Kanwar, were directors of SSMP Agro Export Private Limited, which pursued the same line of business. Now the company the CIRP of the company commenced on 27/8/2018, and then the company was ordered into liquidation on 31/7/2019. It was observed by the liquidator that a plot of land in Chittoor was sold on 13/12/2019. An agreement for sale was entered and the company had received 1 crore of rupees, which was not deposited in the name of the company, but was deposited in the name of this company which was owned by the sons, SSMP Agro Export Private Limited. The liquidator objected, wanted the money back. Then the company went into and filed, despite the land being sold in 2019, they said that there was a rampant fraud which was committed and a police complaint was lodged on 12/12/2023, 4 years apart. Now, and there was also in the books of accounts of SSMP Agro Industries Export Limited, it was shown that this was an unsecured loan obtained. There was no board resolution, nothing else whatsoever. And there was no doubt that this was a related party transaction. So, as far as Honorable NCLT is concerned, they said that this money should be repaid back to the liquidation estate. NCLT said that they're aware of the criminal matter, which may go to criminal court. But fact remains that in Insolvency Bankruptcy Code, we have to look at the intention of the parties and how things have unraveled. And post-order, I mean, when this agreement for sale was entered, the company was already in liquidation. They had no right whatsoever to sell the company as to enter into the agreement of sale and receive 1 crore rupees and put it in their account. So this was the FIR which was lodged in 2023. The loan shown in SSMP Agro Industries Export Private Limited were all afterthought and mostly thought during the NCLAT appeal process. So this was a clear case of fraud. And you will appreciate that in this, both section 66.1 and 66.2 are getting involved. Why? Because as far as the fraud committed by Manoj Kanwar, his wife, and Braj Kishore Devi, who are directors of the company, 66.1 gets involved. But whereas, as far as the sons, that is Shrey Kumar and Sagar Kumar Kanwar, 66.1 gets involved. And in the case of Manoj Kanwar, 66.2 gets involved. So both are getting involved. And so I have put it in 67, because 67 deals with the punishment, which comes in 66. So the court held that the learned A was therefore justified in proceeding with the material before it and directing restoration of rupees 1 crore to the liquidation estate in order to safeguard the creditor's interests. So this is a nice case, a complicated case, and deals with related party also. And this sort of things do happen. And I'm happy that NCLAT are looking very deeply into this kind of things. So with this, we move on to the next topic. Hope you enjoyed hearing about this case. We are now on the screen of section 54, that is dissolution of corporate debtor. We are coming to topic number 7. But before I begin, I must say that this is not a judgment of February. This is an old judgment, but I thought it is relevant to explain to you because dissolution of a company is a very important thing. So with that in view, and this is an eye-opener, because we often get cases from NCLT wherein we see that a company has no assets. And liquidator is supposed to get paid out of the sale proceeds of assets. So literally, therein, liquidator becomes a bonded labor. He has no money to get. He has to file progress report and this and that. So how do we solve? Or even for an RP, he comes up with a case, he gets a case wherein there is no asset. There are only liabilities. So what do we do? So the topic says that an application can be filed for dissolution of a company as no fruitful purpose would be served in keeping the present winding up proceeding pending. Let me read out the topic once more. Application can be filed for dissolution of a company as no fruitful purpose would be served in keeping the present winding up proceeding pending. The cases of Messrs. Macmillan Enterprises versus Messrs. Ravindra Raikem Private Limited. It's a Delhi High Court judgment. This is a landmark judgment which is being followed by everyone. I mean, in many cases. So I would strongly recommend that you go through this. Before doing this, I would also like to show you one more case. That is topic number 4. An RP can send intimation to the registrar of companies giving the facts and details, praying that the company's name be struck off from the register of companies. This was held by NCLAT In the case of Janak Jagjeevan Shah versus Committee of Creditors, this is also a pretty recent judgment. An RP can send immediately, can send intimation to register of companies, giving facts and details, praying that the company name be struck off from the register of companies. This case should also be looked into. This, of course, with the permission of NCLT. RP cannot do it on its own. So let me stop the screen share and take you to the slide. Now, in this particular company, the Honorable High Court observed that the company in liquidation was ordered to be wound up on 15/1/2002. The official liquidator visited the registered office and no possession could be taken since one of the directors was using it for residential purposes. Company had secured creditors. As per order of the court, 24 lakhs was paid to the security creditors by one of the directors. The company had receivable from 3 companies, but nothing could be recovered. The company in liquidation has no assets, either movable or immovable, from which any money can be realized, and funds position of the company as on date is on 24, that is 8/5/24, is stated to be minus 22,681.88. The process of liquidation has been carried out in full. Affairs of the company in liquidation has been put up. So the present application has been filed for dissolution of the company in liquidation, as no fruitful purpose would be served in keeping the present winding up petition pending. So the Honorable Court observed that when affairs of the company have been completely wound up, or that the liquidator cannot proceed with winding up of company for want of funds or for any other reason, the court can make an order for dissolving the company from the date of the order. Now, here I would like to emphasize that this was a Delhi High Court judgment concerning Companies Act. So in Companies Act, there was no concept of resolution professional. So it is not necessarily, since there was no concept of resolution professional. So here this applies to resolution professional also. So a resolution professional, it has been held by NCLT, Chennai bench and some other bench, that directly from CIRP one can move for dissolution. And this is a High Court judgment which is going to end, because at that time this judgment relates to Companies Act, wherein there is no question of RP being there. Now, before just doing this case, I showed you on the screen the case of Janak Jagjeevan Shah versus Committee of Creditors, in which the court, Honorable NCLAT, categorically held that an RP can send intimation to the Register of Companies, giving facts and details, praying that the company's name be struck off from the Register of Companies. That is akin to that of dissolution. So there is no need of filing preliminary report. There is no need of filing asset memorandum, because those are meaningless, and going ahead with the entire process. So this is one thing, this is very important, so which we should keep it in mind. And this is not only for resolution professionals, this is not for insolvency professionals alone. Even for corporate debtors, even for banks, this is an important thing which one should remember. So with this, we move on to next topic. Viewers, we are on the dashboard of Section 67 of Insolvency Bankruptcy Code in corporate insolvency, which pertains to fraudulent transaction. But this particular case which we are going to discuss with you is not exactly connected, but this is a Supreme Court judgment concerning serious fraud, essentially PMLA, that is money laundering case, and what Supreme Court observed in this particular thing. So this can very well apply to Insolvency Bankruptcy Code, because in any case, the company concerned is already in insolvency, and the process is going on. The topic is, in case of serious fraud, the accused may not be allowed to leave the country. We know that in bankruptcy it is done, but even in fraud, this can be. See, the Supreme Court can order that the person should not be allowed to leave the country. This is the case of EAS Sharma versus Union of India and others. The Supreme Court judgment. It pertains to Reliance, Arcom, then Reliance Power, Reliance Infra. This is a short judgment, but worthwhile. Definitely a worthwhile read. So while recommending you to go through this, let me take you to the slide share to make things more interesting. Now, what Supreme Court observed was that the investment made by Yes Bank between 2017 and 2019 in NCD and commercial papers, both with RCFL and RHFL, are being examined. So there were definitely irregularities in that. RHFL borrowed public funds from 33 banks and financial institutions and committed a default of 7,523.46 crores, out of which they could recover only 2,116.28 crores, with a net default of 5,407.18 crores, which constitutes proceeds of crime. 21 banks, financial institutions have been defaulted to the tune of 6,280.57 crores, as out of 8,226.05 crores. Only a sum of 1,945.48 has been paid. In another case, in relation to Reliance Communication, ARCO, points out the total outstanding amount is 40,185.55 crores, which constitutes proceeds of crime. In the third case of Reliance Power entered into a power project agreement wherein forged bank guarantees were submitted, resulting in loss to the exchequer to the extent of 105.98 crores. That's 106 crores. CBI in this case came and submitted a report that they have received a complaint from State Bank of India and other banks. And they're investigating and they have lodged an FIR and they're looking into it. Supreme Court came heavily on CBI and said that it is imperative upon CBI to investigate the conduct of the bank authorities to determine whether financial assistance was released in collusion and connivance with management of the defaulted company. This is a very, very serious and very, very serious observation. It is imperative upon CBI to investigate and conduct of the bank authorities to determine whether financial assistance was released in collusion and connivance with the management of the defaulted company. Those accused will not leave the country without prior permission of the court. So this is an eye-opener. The courts are opening up. Courts are becoming very heavily on money laundering, fraud. So this, we have to keep it in notice. And this is an eye-opener because this is beneficial for the economy. No one can take the country's economy for a ride. So with this, we move on to the next topic. Viewers, we are on the screen of Section 94. Section 94 deals with application by debtor to initiate insolvency resolution process. This comes under personal insolvency as well as insolvency of personal guarantors. Now, the topic says the mere fact that application is filed, consequent of which the recovery proceedings may be halted, cannot lead to the conclusion that intent and purpose of the application is malicious and fraudulent. The case is of Nasima Banu versus State Bank of India and others, company appeal so and so. This is the verdict of 23rd February 2026. I'm reading out the topic once more. The mere fact that an application is filed, consequent of which recovery proceedings may be halted, cannot lead to the conclusion that intent and purpose of the application is malicious and fraudulent. Now let us go to the case. This is a small case, 4-page judgment only, but a radical judgment. It shows the viewpoint of the court, which is rather different than what we have seen earlier. The company had moved a 94 petition, and State Bank had opined that this was moved with malicious intent. So I would require, while recommending you to go through the judgment, I would rather stop the screen share here and take you to the slide which I prepared for you. This is a small judgment, as I told you. The highlights are the mere fact that the application is filed, consequent of which recovery proceedings may be halted, cannot lead to the conclusion that the intent and purpose of the application is malicious and fraudulent. The appeals are accordingly allowed. The matter is remanded back to adjudicating authority for its consideration other than that which formed the line of reasoning in the impugned order. In this case, State Bank had come up with their own case of Section 65. And they referred to Getz Cables Private Limited versus State Bank of India of 2024. The judgment read as follows, which is very important part of this particular presentation. Para 31. We are in the present case considering the question as to whether rejection of Section 10 application on the grounds of invoking Section 65 is justified or not. There are no other facts and grounds pleaded to prove any fraudulent or malicious intent by the CD in filing Section 10 application. For allowing Section 65 application, fraudulent and malicious intent of CD has to be proved from some materials of record. Merely because proceeding under Section 13, subsection 2 and 4 has been initiated by the creditor prior to filing of Section 10 application cannot be the ground to hold Section 10 application filed. Is filed with malicious and fraudulent intent. For proving fraudulent and malicious intent, something more is required to be pleaded and proved apart from initiation of proceeding under Section 13, subsection 2, subsection 4 by the creditor against the corporate applicant. Here 13 and 4 refers to surface. In para 33, the court observed that as observed above, the basis of rejection of stay in application is the finding of adjudicating authority that the application has been filed with malicious and fraudulent intent to delay and halt the recovery proceeding. The mere fact that the application is filed consequent of which the recovery proceeding may be halted cannot lead to the conclusion that the intent and purpose of the application is malicious and fraudulent. We thus are just satisfied that the adjudicating authority committed error in allowing Section 65 application filed by State Bank of India. So while in Section 10 it can be, Section 65 will not be allowed. Why not in 94? So this is an interesting read and quite a different judgment from which we come across. So that is the reason of my bringing this to your notice. I hope you liked it. Let me move on to the next topic. Viewers, you can see on your screen the dashboard of insolvency, resolution, and bankruptcy for individual and partnership firms. We are in section 112. 112 is a report of meeting of creditors on repayment plan. Our topic is Regulation 19 of 2019 regulations is thus only procedural provision and has to be held to be directory. Now, let us simultaneously open personal guarantee, go to insolvency, and check what is Regulation 19. Regulation 19 says, the resolution professional shall file repayment plan as approved by the creditors, along with the report mentioned in section 106 or 112, as the case may be, with the adjudicating authority on or before completion of 120 days from the resolution process commencement date. The subsection 2, subregulation 2 says that the resolution professional shall provide copies of the documents filed with the adjudicating authority under subregulation 1 to the guarantor and the creditors within 3 days from the date of filing. So it is mandatory to file as per regulation 19. the report of the resolution professional pertaining to repayment plan with the adjudicating authority within 120 days. Now let us come back to section 112. So we are finding what NCLAT has said, the regulation 19 of 2019 regulations is thus only procedural provision and has to be held to be directory. The case is Purushottam Behra versus State Bank of India and others, company appeal so and so of 2026. Needless to say that this is a very, very recent case. Now, in this case, what happened was the Section 100 order came out on 1/10/2024. So accordingly, after 180 days, that is sometime in March, 31st March, the moratorium was coming to be over. The repayment plan was filed later, submitted later, and this is an interesting read. I am not going into details of the case. I would rather request this is a very interesting case, and I would request the viewers to go through this case. I'm taking you to the slide which I prepared for you for this purpose. As I said, the order under Section 100 was passed on 1/10/2024. Regulation 19 of 2019 provides for filing of the repayment plan as approved by the creditors on or before 120 days from the commencement date. Section 101 provides that moratorium will be for a period of 180 days or on the date of adjudicating authority passes an order on repayment plan under Section 104, whichever is earlier. So in the present case, no order was passed under Section 114. Thus, moratorium came to an end on 31st March 2025. In the present case, repayment plan along with the report was submitted on 9/1/2020. That is before the repayment plan, before the moratorium period came to be over. The 180 days of PIRP came to an end on 29/1/2025 without approval of repayment plan. The repayment plan remained under consideration and ultimately has to be approved with 100% voting of the creditors on 6/12/2025. The third meeting of creditors were held on 17/5/2025. Remember, think of it. 31st March, 17/5/2025. Authorized RP to file the application for seeking extension of the insolvency resolution process by 150 days. So that means they wanted a further extension of 150 days. Adjudicating authority, noticing the provisions of Section 101 of IBC, took the view that the scheme of IB Code in relation to PIRP process is to complete the process within 180 days and it does not provide for any mandatory consequences. The conclusion under Section 101 of IBC provides that the limit of moratorium and conceding any power to the tribunal and adjudicating authority to extend such period shall completely be against the statutory scheme. So, in this particular case, NCLAT held it had a repayment plan which is approved by creditors. Point. Now, disapproving the plan would result in bankruptcy, and that would be unjust. So, considering various other cases and things, NCLAT came to the view that Regulation 19 of 2019 regulations is supposed to be procedural provisions and has to be held directly. The repayment plans has already been approved by 100% creditors, hence above application by extending the period of PIRP till 15/3/2026 is allowed, during which period the RP to submit the report before the adjudicating authority for passing an order of repayment plan. Fine, I'm not an adjudicating authority. But had the situation been otherwise, in one of my case being handled, a repayment plan which is rejected by the creditors is lying at the adjudicating authority for more than a year. Now, the purpose of PIRP and bankruptcy is to end within 540 days. If 1.5 years the plan lies with the adjudicating authority, who is at fault? Because in PIRP, the convenience of the personal guarantor has to be looked into. So this is a big question which the judiciary has to look into. I'm not criticizing the judgment, but this is an opinion from an independent person. So with this, we move on to the next slide. Here, as you can see, the dashboard of section 238A, which deals with limitation. Now we come to topic 51, which says that in calculating limitation angle, the order of the Honorable Supreme Court passed in suo motu writ petition number 3 of 2020, the period of limitation from 15/3/2020 till 28/2/2022 has to be excluded. Come to think of it, we are 4 years ahead. We are now in 2026, and still now we are getting cases pertaining to CIP. What a devastating effect COVID-19 had. Now we are coming to case of Encore Asset Reconstruction Company Private Limited versus Pandey Construction Private Limited, Company Appeal so and so. This is judgment of 17th February 2026. This, I would say, is by far one of the best judgments on this COVID-19 period, and the twists and turns in the judgment is really makes it readable, worth reading. This is a fabulous judgment. And I would strongly recommend that you should go through it. Those highlights of the judgments would give you a very clear idea of what it is. But still then going through the judgment, excerpts from the judgment would have an effect. So let me take you over to the slide. This judgment pertains to a corporate guarantor. The entire loan and the entire portfolio of the financial creditor was assigned to Encore Asset Reconstruction Company on 15/5/2019. The demand notice under Section 13(2) of SARFAESI Act was issued by DNS Bank Limited on 4/9/2018. The date of default mentioned in the application is 19/11/2019, which is 15 days from the date of default, which is mentioned at 4/11/2019. 15 days added. Since the limitation period would have ended beyond 28/2/2022, the issue will have to be considered in accordance with the Direction 1 and 2 of the order of the Honorable Supreme Court in the suo motu writ petition. Applying Direction 1 and 2, adjudicating authority concluded that the balance limitation period from 3/10/2021 to 18/11/2022 would be 411 days, which would be available with effect from 1/3/22 and would expire on 16/4/2023. This petition was filed on 20th August 2023, so this was beyond period of limitation. Applying Principle 2, Direction 2, only 90 days would be available for preferring an application under Section 7, which would end on 28/5/2022. And as the petition was filed on 28/2023, the same would be barred by limitation. However, Honorable NCLAT took altogether a different view. It held that since the date of limitation period was falling beyond the date stipulated in the order of our Honorable Supreme Court, that is 28/2/2022, the whole period, that is from 15/3/2020 to 28/2/2022 would have to be excluded. And if that period, this entire period is excluded, and then the limitation period is calculated, then the petition under Section 7 was filed very much within the period of limitation, allowable under the period of limitation. Now, it took another turn. The borrower acknowledged the outstanding concerning the facility granted by DNS Bank Limited in its proposal of settlement dated 10/11/2019, based on which financial creditor once again issued a demand notice on 18/2/2022 to the city, invoking corporate guarantee, wherein the demand of 28.22 crores outstanding was demanded as on 15/2/2022. The notice given under Section 13(2) of SARFAESI Act on 4/9/2018 was, and the acknowledgement made on OTS dated 10/11/2019, which is within 3 years from 4/9/2018, had further extended the limitation period till 10/11/2022 by virtue of Section 18 of Limitation Act. Since the last date of limitation period, again, the same thing, was falling beyond the period from 15/3/2020 to 28/2/2022, the whole period would be fully excluded for filing the petition under Section 7 of IBC. And the petition filed on 28/2023 would be within the period of limitation. So the Honorable NCLAT opined that the adjudicating authority has not considered the law laid down by Honorable Supreme Court in suo motu writ petition number 3 of 2020 in correct perspective, and also failed to take into cognizance Section 18 of Limitation Act. The judgment passed by adjudicating authority may not withstand the test of law and therefore is liable to be set aside. The entire thing was sent back to adjudicating authority to be freshly adjudicated. So this is a very interesting read, and please go through the judgment. With this, we move on to the next slide.
Viewers, we have come to the end of the presentation. Guide to IBC is not my website, it is your website. It is website for the entire fraternity of not only insolvency professionals, for the corporate debtors, for the COC, for even the corporate debtors. Those who want to learn IBC, it is for them. And this is really a magnificent enactment, I would say. So let us make use of it. Please share the video with your friends and relatives, friends, associates, relatives, and others, and help us in growing this website. With this, and I wish you a very, very colorful Holi. Thank you so much for watching. Bye for now.